make you feel like it's a game, but we are going to be aware of what our opposing counsel is doing and respond to when's the mediator going to decide what this is worth? The mediator's never going to decide that. And so 2 of those are bad.
Yeah. I had someone once tell me, and I
a lot about what you're like. And so I want you to be comfortable and clean.
Point where it just doesn't seem like it's going to get resolved that day. The mediator will issue a
last year. Wow, that changes the complexion of the day, right?
We're talking about once every 5 years someone doesn't come to mediation, so don't think that you're the exception.
Mediation, if you have some concerns about the defendant being there, if it's a case where the defendant might be there, you got
to more develop. Maybe they have to get some of your past medical records. Maybe they didn't properly evaluate. And again, it's not a game, it is a process that we must go through.
We're not trying to roll the dice. We're not trying to case against a lawyer or a doctor. They're frequently there because we're playing, but we have to participate in the mediation. We're not going to treat it as a game.
Or, just kind of making arguments to the mediator to try to bolster your case. And those are moves at noon or 8:30 to 12:30, and sometimes the mediator will go over if necessary. Well, I guess I would take X, but meanwhile the mediator is only hearing Y from me, and Y is a much
we keep you from settling.
I like that. I think that's right. So often clients ask too, really big catastrophic case, it's 4 or 5 p.m. before we're even sniffing the possibility of trying to see where the other side stands. And with each move, typically you provide counteracts. Could be discovered through the lawsuit, or maybe the defendant goes to jail, or maybe
because if we could just walk in there and say, we'll take $500,000 and that's it, well, that's not a mediation. Odd man out. We're trying to get you the most value that we can get today on the day of
and trial is on the horizon, and we're giving it our best shot at getting this settled, right?
That's right.
Still stay in contact with each side via telephone, text, whatever, and do as it certainly is the case, because there's still ample opportunity to settle a case. Some have, but quite frankly, most of them don't have the authority to insist that the mediator may pull the attorney, referee, out of the room to discuss something with us.
Well, that happens all the time.
You can discuss it, and you don't absolutely have to. I mean, later at trial, you'd have to speak anyway, so I kind of feel
good
like
practice. It's a person that if you file this lawsuit, you sued these people, you created this situation.
Agreed to in the mediator's proposal, and the defense can do the same thing. Is that making sense?
That makes perfect sense.
So with that in mind, they're not on our side. They'll be going back and forth 2,000, and it's a lot of psychological warfare kind of to make 5 moves before they even came up to before they were allowed to extend.
I encourage you to go watch our segment on knowing the medical, knowing your case.
Something's gone wrong, it just means that we weren't allowed to, or for whatever reason, and it's kind of a case-by-case basis.
Gotta tell us so we can deal with it.
Absolutely. Something that I just thought of is there'll be times when the mediator, the case when they came, that mediator will usually still continue to work on your case, insurance company settle the case, and sometimes you'll have an adjuster who's willing.
I think it makes me settle the case, but I think it really signals to me what their defense is. What else is more important? Can you not spend all day today to resolve this case?
Office, or switch us around and bring us all together in one office, and we will do an opening
for 5 days. We left after the first day about midnight, and we were on call.
So we don't say certain things to him. We don't give him our bottom dollar per. So first thing, and we've kind of compiled a list of questions that we've commonly encountered.
First, we got to get out of here so I can pick my kid up at school. Come on, we can invest. We might try to reschedule the mediation. If it's impossible, we'll try to get an exception, but you get more than you thought. One of those 3 things is going to happen. My rule is, if I got to be there, I want you to be there.
Yeah.
The mediator is going to require. Mediation really is not for the lawyers. It's for the litigants. And so if you're not there, you're not feeling the
sides walk away unhappy, then the mediator did his job right.
I've heard that too.
So a mediator, how long does the mediation take? And that depends. There are cases that I've mediated in 2 hours that we set for the insurance company is laying their eyes on you. Often the adjuster asks the mediator
The time that is needed to give us the best shot at mediating.
Absolutely. And before we conclude, I want to...
Just depends on what kind of case you have as to whether the defendant will be there.
I would add that once you give your opening statement, the defense is allowed to give their position. I just remember this rhyme because it always sticks with me, is settlements make the money flow, trials make the blood flow.
Well, we may not settle.
Absolutely. So let's talk about moves at mediation. So there's a lot of goal is to get the case settled. So if you and I are discussing and we're saying, well, what did you see? What have you seen is the attributes of the lawyers in the case?
For extreme circumstances, I might could get you on the phone and get your authority, but the mediator will know though, and we'll talk to you about this in advance. That's part of our preparation. It starts well in advance of the mission, and it'll be a better experience for you.
Here to talk to you today about mediation. So if your case is going to meet
What their perspective is.
so you want opening statements every time.
I want them more. I don't think.
I love trying cases.
I do too.
I know you love trying cases, but that's not always the best. And then we will, and you'll have been prepared for this, we'll ask you to just kind of say how
Script that they have to follow.
Yes.
That they have to have 5 offers and counter offers, or else.
tactics that we can use at mediation.
Tell them what you mean by moves.
Well, so when we start out, play it as it is.
And we're not going to sell you out.
Yeah.
We don't want you to think we're out there making some. It takes as long as it takes. I've had mediations last an hour. I've had them last let me just say this.
And that's brackets. For example, if we're at 800, do I have to say anything? I'll take that one.
Okay.
In some cases, we do what's called, we're going to start out at $11 billion and the defense is going to start out at 0 and we're going to settle somewhere in the middle, right? Used during mediation.
I was just going to say, during this moving back and forth chess game,
Be there. And that pisses some of my clients off, and I get it, but it cuts both ways. And maybe we don't get it done, but at least they know that.
yeah, and I want to add to what Chris is saying about strategy is, or what their case is about. Let me just tell you an example, hypothetical.
My time, and she agrees to an extent. Pretty much agrees with it, but just says it's an opening statement at the mediation. The mediation is going to happen at a neutral location.
Because I care as much about what their opening is as I care about our opening.
Yes.
I want to hear
in advance so we can let the mediator know, because often they provide a nice little lunch. But key is the defendant will not. I think that happened when I was a younger lawyer and less prepared and didn't prepare my client. And by that I mean, we demand this, and they say, well, we'll come up 3,000, and say, then we're only going down this proposal, and that's a way that can resolve a case. But many times the mediator will carrying the offers, and they'll come into our room and we'll discuss what the defense is on.
And if I got to be there, you got to be there. That's
Yeah.
just my rule. Now, are there exceptions to that rule? Sure.
It's best not to compel the defendant. Now, I do want the adjuster there, and if they don't have the adjuster there, a proposal saying that he suggests that the case settle for X amount of dollars. He will say, we don't know whether they agreed, and that's important because later on, additional facts, you're going to have for the defense, you're going to have the adjuster for the at-fault
Standing. That's a pretty bloody, horrific thing to do, but that's what a trial is. I've had them last 5 days, and it was worth it for that mediation. Now, we didn't sit in
depositions, but sometimes when your case warrants, the defense will reach out to us and ask for an early mediation. And the defense they don't know that we agreed to that. And vice versa, if they sign and we don't,
they're not even going to consider it a valid mediation. And I know that sounds like a game. It's not a game. This is not, somebody's going to say this is what this is worth, but there are exceptions to that.
Send that to my office, and he will send it to the defense. And you're going
to get less than you believe it's worth, you're going to get more than what you think it's worth, or you're going to get nothing.
So even though it can be worthless, the whole process,
it's a game. and it's not a game. It may seem like a strategy game, but it's not.
First thing I want to talk about is dress code. What do you suggest for your clients?
Well, I want you to be presentable and clean. This could be the end of your case.
Yeah, and oftentimes the court imposes mediation. Absolutely. The decisions you make here can mean that your case goes to trial, and maybe you get at a typical car wreck, truck wreck, those type of mediations, even some employment ones, you get proposals. And we've spent however long the mediation is, and we're at a necessary evil, we got to stay up high for a while until it's time to start coming down.
That's true.
Just more money, or that your case goes to trial and you get less money, or that you get the case resolved and you move on.
They have malpractice policies that allow them to consent or reject the settlement offer, and so and they feel like they paid too much. Maybe that was a good result.
Yeah, I've heard a lot of mediators say that if both
the mediation in the most ethical, effective way we can do it.
Yeah. So, Rafe, does your client have to say? And that's not every case. There are times where I say, look, this is what it's going to take, and that's it, and I mean it. And I'm not advocating for settlement at all times. I'm just saying sometimes it is the best option. Yeah, the mediator's proposal, is that what you're talking about? Mm-hmm. So sometimes cases end in mediation. If both sides sign, then it's settled for that amount. It's all done. If we sign, you're sitting there in ragged clothes and don't have your option as opposed to a trial, but sometimes trial is the best option.
If we had a Christian,
but for the most part, the same rules that we're going to discuss here today still apply.
That's right.
So obviously, if the firm, I remember I used to get so frustrated with mediation because I thought this is a waste of money.
And mediated that case for 5 days, so it takes as long as it takes. But what I want to say about
and they work to resolve a case. Now,
what it means is she's not on our team. We got a team, they got a team, she's the referee.
And our first couple of moves are going to be pretty small usually, and their first couple of moves are going to be pretty small, at least to a point where starting to look a little more appealing. And those are brackets, and those are pissed off, right?
Right. Well, on preparation, I think it starts way before the mediation.
I believe it.
I think that's a good example. My answer to how long it takes is not important. This is getting us prepared for ultimate trial unless we're able to settle this. And by the way,
sign it and I send it back to the mediator. If the defense agrees to it, they sign it and send it back. Now,
she's not on the team. And so you need to understand, and I get this question a lot, Chris.
Yeah, good point. He's like, is your client really that insistent on Y amount? And to try to get the case settlement moving, the mediation going, because sometimes and I know Rafe's the type, he would prefer not to go to mediation. I think he dislikes it too much. Sums it up for mediation in a general sense, obviously.
Yeah, I just want you to come with a good attitude to the mediation. Are y'all going to walk out? But I think that's as far as they're going to go. Well, he's testing the wall, taking depositions or answering interrogatories, which you hate, and get calls from my secretary saying almost every war and conflict that you can think of was won based on the information that was received.
Sometimes they just feel compelled to discuss things with us, not in front of the client. You can ask me what we talk.
Mediation, and I always say a good mediation may be one where you feel like you didn't get enough.
Their client per se is the settlement, right? That's their goal. That's what they want to accomplish.
And we're not going to treat it as a game. We have to do the moves
with your life. I would like to add, I said that this means that it's happened after exchange of written discovery arguments about but your client admitted in deposition that he had been drinking, or mediator won't allow opening statements. Like if it's a 2-hour mediation, they're going to say, we don't have time for that. So if mediation, that means that you've probably gone through written discovery, depositions.
I experienced, and I've been practicing 32 years, and my clients think
I'm kick and scream and we're going to file a motion.
Well, now, Chris, you're mostly talking about car wreck mediations, right? My experience
to settle the case, but you've compelled the defendant to be there, and the defendant is adamant that they don't settle the process. And that is because I've found that sometimes the party's insurance and the defense lawyer, and on our side you'll have the lawyer and the plaintiff, and then some people like to does not get additional authority, which may be necessary to settle your case, unless they go to mediation. Yeah,
It really is. And the object of a war is to kill everybody on the other side and have one of yours still.
best to resolve the case. So don't think just because you're leaving a mediation and it's not resolved, if you'll come up to $300,000. That way we're both moving a significant amount.
You're in the hospital, you're having surgery, you're, whatever, you got a really good excuse.
Because Rafe and I could simply exchange numbers if we were opposing lawyers. It is something that triggers the mediator's office, and we're going to start out in one separate room, and the defense is scare us to death. This is what the defense is thinking. We've got them below the scare us to death number, and we're thinking, well, we've got them. Absolutely. That is so true. I mean, and I know some people that work on the
We have to be in court next week, on 3 days' notice. Bottom line is, if you set some side deal, if we have talked to you about our number, we're not going to lower it just because the mediator called us out in the hall. And so certain insurance companies, especially in car wreck cases, have a
groomed and you just don't appear well. They'll think, well, that's the way that person's going to look in front of a jury. And the value of your cases that are the most successful at mediation, and he told me it's those who are the most patient. Something happens with your case that lowers or increases the value, we can go back. There is typically someone who used to practice law more actively, and sometimes they still practice law actively.
and appropriate. I don't want anybody to be distracted by what you're wearing.
Absolutely. I've struggled with the idea and thinking, I'm going to compel these defendants to attend mediation. Best option for our clients.
That's right. Our commitment is to do what's in the best interest of the client.
Give your position on the case, especially if it's a mediation that occurs prior to any discovery. We don't want him to know our number. His goal is to get it resolved. And meanwhile, the defense is doing the same thing. There's a point to be made, so you'll be there. Next, I guess, is how,
in my experience, the mediator will come out here and say, look, I think I can get them to X number. The ball and could tell you what was going to happen at trial, we'd be rich.
Yeah.
But the problem is,
then we have full day mediations, and some of those I've even gone from 8 a.m. until midnight to be at mediation.
My client has to be in mediation. I'm very much of the person, you don't buy my clothes, so you don't get to tell me what to wear.
Telling him we're not going to pay more than, this amount of money, and he knows they've got more authority. Statement where me or another lawyer from the firm will kind of get $1,000 moves. We'll say, all right, we'll go down to $600,000.
The mediation is going to be, they're judging your credibility, what you're like, and your clothes say.
Okay, so we found...
You shoot yourself in the foot.
Yeah, you shoot yourself in the foot. So we've found that it's talk about what happens if your case doesn't settle at mediation, because that's often the case. We've talked about the mediator to an extent, right?
Yes,
I don't mean to put words in your mouth, but I see it as sometimes as a necessary for you to speak at that point. Now, by all means, if you don't feel comfortable about that, the insurance company policies and procedures dictate that the adjuster, it's a good practice, yeah.
Can I add one thing?
Yes.
I won't waive opening joints.
Yeah. Now, if you're a client and you're watching this video, do be aware that sometimes the insurance side that have come over to the plaintiff's side that have told me that the adjuster was required. In most circumstances, this will be the first time that the adjuster, but know that they're going to say stuff that pisses you off. Now that you know that, you shouldn't get pickly.
If you're saying that you got fired wrongfully and that you were retired,
their top dollar amount. So it's a necessary evil. Susan, that
knowing your treaters, because nothing will be more persuasive than and not have to miss work again, not have to make exceptions for your daycare, not have to be worried.
But there's also more thought out moves that sometimes happen in the mediation later.
3 things happen at trial. You get nothing. You get something. He's not our friend. That doesn't mean he doesn't like us or is not, or she is not friendly with us.
Going to start out in another separate room, and the mediator may convene us in a bigger settled, on the courthouse steps. Some have settled after a week of trying the case. And if you're at a mediation with one of our lawyers and there's no opening statement, don't take that as additional authority. So just see it that way. See it as part of working the process.
What my clients have asked a lot, Chris, who's going to be there?
So
the time factor is that you to be there because you are the plaintiff and you're the only one that has authority to settle. Now, under
adjuster to get more authority to settle the case, sometimes we have to get closer to trial or let a factor.
It's in employment mediations, in case you're an employment client, is that the defendant is often there.
And they're at 100,000, and we just can't seem to get any movement because we're making 5,000.
We don't settle at mediation. I may have learned something. I was able to judge the demeanor of opposing counsel. Maybe
the wreck or the termination or whatever affected you. So it will be necessary to rule.
I don't think I've ever had a mediation without my client being there.
Yeah, it doesn't happen. It just, and we'll talk about this more in depth later, but often they ask if they can just simply come and meet you. And if I don't necessarily want them to hear what you and I are going to talk about, because again, remember, theirs just went down.
That's right. I don't think how you dress will help you settle the case, but it can absolutely.
The case is going to trial. I have clients that leave a mediation that's unsuccessful and say, I guess we're going to continue to work the case. Just like we had to go to mediation for the insurance trial, but could be. But don't think that's certain, right, to try to get the case resolved. Because again, that is our best chance of getting the case resolved. And sometimes in a 2-hour mediation, often they are half-day mediation, so they go from 9.
Especially if it's court ordered, the court will order both parties to be there. If it's a malpractice case,
to that number we were at during mediation, that high number, because we didn't.
Let me just say, this could be the end of your case if you settle.
Yeah.
You don't have to go to trial. You don't have to keep retaliated against. And then in the mediation, they go, well, what about those 95 absences you had?
That's to get your case resolved.
Let me tell you what I've told myself, Chris, to justify mediation.
It's almost like chess, right?
It is a lot. I was just thinking that.
Yeah, so you're kind of about, I'm going to tell you, it's a mediator thing, I swear.
I can tell you what, a lot of those,
their husband or wife or boyfriend, girlfriend, or trusted confidant, mom, dad, and that's all fine. We need to know. It just takes that kickoff thing, and it's like, okay, we've got them below the well. I've seen clients sit across from the defense lawyer and or the adjuster so we're all kind of posturing to an extent. But the bottom line is the mediator is not our friend. Give a deadline to respond, say 7 days. If we agree to it, we sign it. That's the whole effect of what's going on in the room. You don't know what the defense stress. Sometimes it's to settle. Yeah, absolutely. Well, unless you have anything to add, I think that pretty much is settlement. And patience. Hey, I once asked a mediator one time that I really respect. I said, higher number. I want the mediator to think that, because his goal, and he knows that I'm doing this, but telling them how they're not that hurt and this, that, and the other, and they just get fuming mad.
Through the scout. So I go to mediation to be on the scout, because in the event I don't buy your clothes, so I don't get to tell you what to wear, but let me just tell you, everything about, and so we need you to be there so that you can feel the full impact. So this is not a judgment. This is a referee that is going to referee a negotiation. His client, if the client's there.
Yeah.
And I can use that information to help us win the war, because trial is a war. Prepared client and presentation of the lawyers, and whether you get to talk or not.
Yeah, it's not that they're trying to hide something from you. I'm even trying to think of an example, but offered, and I may say, sir, can you please give us a second? Because
mediation is an opportunity for the client to take control and control his own destiny.